Thank you for joining us for CBOR Con Ed. I'm Nancy from CBOR, and I'm pleased to have two of CBOR's favorite instructors, CBOR directors, and attorneys with me to provide you with a state and national legal update today. Thank you so much, Gregg and Eva, for being here. And Gregg, go roll with your presentation when you're ready.
Great, thanks Nancy, and thanks everyone for attending CBOR's online continuing education. We're delighted you're able to make it here. Today I'm going to chat about how COVID infects commercial real estate, a legal update. And we're going to talk about four basic areas. One, we're going to talk about the CARES Act and how the government cares about people in our country and what they tried to do to protect small businesses while the country was going through a horrible economic crisis. We're going to talk about leasing issues, business interruption insurance, and constitutional takings. And normally we have this tradition where someone asks a question, they get a piece of candy. They ask a really good question, they get a couple pieces of candy. We have some technological issues here. We can't really pull that off. So what I'd ask is reach out to me, either give me a call or shoot me an email, and I'll do what I can to give you at least a sweet answer. So let's get going here. First, the CARES Act, Corona Aid, Relief, Economic Security. Again, the concern was back in March, in April, the economy was looking just terrible, and Congress said we really need to do something for small businesses and for their employees. So they came up with something, the Paycheck Protection Program, and they put the SBA in charge of it to administer it, and it was loaning hundreds of billions, which really it was trillions of dollars, to small businesses. And one of the great parts about this is if you followed certain rules, if you gave at least 75% of the loan proceeds in the form of paying people their wages, paycheck protection, and spent the rest on rent and utilities, then the entire loan will be forgiven. So it's like a gift from the government. Now, who's eligible? Under the Act, it said really any business as long as you apply for it and you have less than 500 employees, which makes you a small business. Now, the SBA has been administering small business loans for a long time, and they promulgated some eligibility rules. They said not everyone is going to get this money. For example, if you're a bank, if you're a lobbying firm, certain private clubs, or if you're what's so-called adult entertainment, you're just not going to be able to get this Corona cash. So what happened? There were some small businesses that were in the adult entertainment business, and like a lot of other companies, their business was hurt by the COVID epidemic and by the governor's stay-at-home orders. So they applied for these loans, and they had fewer than 500 employees. So what happened? Their applications were denied. Why? Well, the SBA didn't like the type of business that they were engaged in. They didn't approve of that. So what did they do? They sued. And the question before the court is, if you're engaged in this type of adult entertainment that might not be morally consistent, but you're a legal business, are you entitled to get your PPP loan, your Corona cash? And what the court held is yes, you are. Because when Congress passed this law, in their haste, they said there's only two criteria, under 500 employees, and you apply during the COVID period. Now, whether this is what Mitch McConnell and the Republican Senate intended, we don't really know, but this is the language of the statute, so that's how the court ruled. Are there any questions? Anyone at all? Okay, then let's move on. Second, we're going to talk about lease issues, and this is something that we all lived through when the coronavirus became widespreadly known, and the governors across the country issued many shutdown orders, stay home, stay safe, unless you're an essential service. So people either work from home or some just had to close their businesses altogether. So of course, the problem when you're leasing space and the governor says you can't conduct business, then you can't use your space anymore. So should you have to pay rent or not? That's the question. So there's actually a case, a published case that dealt with this. And here are the facts. The facts are kind of interesting. It was a restaurant, and what they did is they had filed for Chapter 11 bankruptcy protection back in February because they weren't doing great. And then when it came time to pay the March rent, which was the base rent, it was taxes and CAM, they didn't pay it. And then along came March 16th, where the Illinois governor issued an executive order similar to the ones we had here in Michigan, which said restaurants must suspend on-premises food and beverage, but they're encouraged to provide either takeout or curbside pickup or delivery. So, and under the bankruptcy law, what happens is the trustee has the right to assume or reject the lease. They have 90 days. And during that period, you're supposed to continue to pay rent. And of course, here they didn't pay rent. So the question is, under this force majeure clause in the lease, are they excused from paying the rent? That was the issue before the court. So what's force majeure, right? So force majeure means a superior force that impacts your performance under a contract. It means you're not obligated to perform because something outside of your control is preventing your performance. Now, you know, when you see a contract, there's the boilerplate at the back that nobody ever reads. Well, this is the boilerplate of all boilerplate because no one ever reads this until now. And people, why is that in here? Well, now you know why it's in here. Normally, it's a national disaster, an earthquake, a hurricane, something like that, or an event beyond the party's control that just wasn't anticipated. And it depends on the lease contract language and how the court's going to interpret the language. Now, in this case, there was a force majeure clause in the lease. It said each party is excused from performing in the event of, but only so long as it's delayed or hindered by a law or government action or government order. There was also something there that said lack of money shall not be grounds for force majeure. So some of these force majeure clauses, what they'll say is your performance is excused except the tenant still has to pay rent, which is pretty hard on the tenant. But this clause didn't say that. It just said lack of money. So the court looked at it. They said, well, was the force majeure clause triggered by the governor's executive order? And the answer is yes. Did it hinder the tenant's ability to perform? The answer was yes, because they couldn't wait on customers and serve them food and beverages and charge them the money that they needed to pay their rent. So that was the cause of the problem. It wasn't lack of money. Interesting here because they did file for bankruptcy, but it was the governor's executive order that prohibited them from earning the revenue to pay the rent. So what did the court hold? They said the March rent was due because the governor hadn't issued the executive order yet, so the force majeure event hadn't happened. Now, for the later months, they said it's partially excused for April, May, and June. So what were they thinking? Well, what the court said is, well, let's think about this. They could still provide carryout, curbside pickup, and delivery. So their performance was not totally excused, only partially excused. They said, well, how much of the space is kitchen? I said, well, 25%. So the court said, okay, this is what we're going to do in sort of a Solomon-like approach. We're going to say 25% of the rent is due because you could have still done curbside, carryout, and delivery. So you had to pay that. So the tenant had to pay 25% of the base rent, the taxes, and the CAM. Our firm actually had a case not long ago where the tenant, we were representing the landlord, the tenant was making pallets. And they said, COVID, force majeure, government's order, we can't pay. And we took them to court and we said, well, wait a minute. The government's executive order, and she issued a lot of them, carved out essential businesses. And it specifically said a pallet company is an essential business. So we said to the court, hey, wait a minute. They could perform. This is not a force majeure situation. The court agreed and our client won and the tenant then was obligated to pay rent. There's a couple of cases just to mention that are out there. One, this very large New York firm, when Governor Cuomo issued his executive stay-home order, they had this fancy Midtown Manhattan space, couldn't use it. So they're saying we shouldn't have to pay rent. It's force majeure. And there's a very big international firm based in Chicago. They had a $185 million lease for 416,000 square feet. What happened? They stopped using 89% of the space, from 579 in-office employees down to 12. And they said, not only don't we owe rent, but the landlord owes us $840,000. So they had a fabulous force majeure clause. They're a big law firm. They knew how to draft it, right? So it said the tenant was entitled to a rent adjustment for certain unforeseen events, including a pandemic. Now, how they could have thought to put that in the lease, who knows, but that was forward thinking. Next, let's see. Next, there's three basic grounds. Any questions, by the way? There's three basic grounds to try and get out of your responsibilities under a lease based on COVID and government orders. One is force majeure, which we talked about. One is frustration of purpose, and the other is impossibility. So there's this company, I don't know if any of you have heard of it, it's called Microsoft. So anyway, they were leasing some mall space in New Jersey. And COVID came, they said, we're closing our store. Well, they had a clause in the lease that said, you can close the store, no problem, termination early because you're Microsoft and we want you so badly as a tenant, but you got to give 1 year's notice. Microsoft said, not happening. We are not going to reopen under these circumstances. Landlord said, well, we're depending on you. This could have the domino effect. Once you close, the other tenants might close. This is just not acceptable. So this one is working its way through the courts, whether by going dark, the landlord could force Microsoft to go light again, or whether they're going to pay money damages and how that's going to be handled. Frustration of purpose. So force majeure, you look at the contract. Frustration of purpose, the law will put this in the contract. An example is under the Commercial Real Estate Broker Lien Act, right? If you put it in your listing agreement that you have a lien right, then you have it under contract. But if it's not in a listing agreement or a commission agreement, you still have it under law because there's a Commercial Real Estate Broker Lien Act. Similar concept here. So what the law will say is a party is relieved from their duties under a contract where the purpose of the contract has been frustrated by an event not reasonably foreseeable when the contract was made and the risk was not assumed. So what does that mean in English? Let's look at an example. There was a couple who got divorced, and what the divorce judgment said is the wife could keep the house until she remarries or until their minor child turned 18. They wanted the child to have a stable home. Child passed away before age 18. So, you know, very sad. After the funeral, I presume after the funeral, the husband went back to court and said, I want to revisit this judgment. Let's sell the house. Because it's frustration of purpose. The purpose for the wife keeping the house was so that the child could live there. Now the child won't be living there anymore. That frustrated the purpose behind the judgment, so it should be set aside. Court agreed. That's a classic example. Some people have said, what about the Detroit Lions? Okay, I'm a frustrated season ticket holder. I want a refund based on the Lions' poor performance. Can I get that? And the court said, Detroit Lions, are you kidding? Especially last season, it's foreseeable. So there's no way you can recover. But seriously, oh, and by the way, that was supposed to be a joke. A case that did involve the Lions, there was someone who had a contract to operate a concession stand at a place called the Pontiac Silverdome. You might have remembered that. The Lions said, you know, we love the Silverdome, going to stay there forever. By the way, we're closing down and moving to Detroit. So concessionaire said, well, wait a minute. My whole contract is based on the Lions playing at the Silverdome. And what the court said as well, you know, in your contract, you knew at least half of the games would be played away. So the parties anticipated the possibility they might not be playing there, so there was no frustration of purpose. It didn't say whether or not the judge was a ticket holder. Next concept, impossibility or impracticability. This is another one where the law will write it into the contract. So if you have to do something, your performance is impossible. And two possibilities. One is it was impossible when you signed the contract. The other is called supervening impossibility. It develops after the contract. So for example, if you signed a lease 2 years ago and it was a 5-year lease and you want to claim COVID and the government orders made performance impossible because you can no longer occupy your space, that'd be a supervening impossibility. So the law will write that into your contract for you. Impracticability is similar, except it's not impossible, but extremely difficult, very expensive, and loss or injury is involved. So there was a case where a subcontractor agreed to dredge a riverbed and fill a designated area. Well, they couldn't fill the designated area because it was the location of a water main in a right-of-way. So it was impossible for them to perform. And the court agreed, and they excused their performance under that theory. Next, again, any questions? Anyone at all? Oh, I see a hand back there. Oh, never mind. Okay. So business interruption insurance. So what is this about? Let's say your building burns down. Okay. Then you're going to get insurance to rebuild it. But while it's burned down, you can't be operating. So not only will the insurance rebuild, but the insurance will compensate you for the business interruption, the loss of income during that time. So people were thinking, whoa, COVID, government shutdown, my business is interrupted, I'm losing income, time to make a claim under my insurance policy. So what do we think is going to happen? Well, in certain similar, not identical, but similar circumstances, courts have upheld claims for business interruption insurance. One, when there was a release of bacteria in the water. One was a release of a gas from a gas spill. And the other, which fortunately we don't have smell under this computer, but it was cat urine odor. So without contemplating that one too long, but the court, in a separate case, they found mold contamination wasn't covered because they said there was no physical loss or damage. So then that gets us to our current issue. If you have a number of employees that test positive, results in interruption of your business, or just the government order shuts you down. I mean, that seems like business interruption, doesn't it? That the government's interrupting your business. Well, there was a case in Lansing. It was a restaurant. They brought a business interruption claim based on Governor Whitmer's stay-home order. They said people couldn't come eat at our restaurant. Our business was interrupted. We're making a claim under our insurance policy, which makes sense. So what the court held, they looked at a couple of things. One, they said, well, we think there has to be a property alteration. There has to be some kind of physical damage in order to get to the second level of business interruption insurance. They said, besides, the policy contained a virus exclusion that said you couldn't recover, so you lose. And there was a New York case also. It was a printing press company that was shut down by Governor Cuomo in his executive order. And the court there said, well, no physical damage. They said COVID damages lungs. It doesn't damage printing presses. So think about that one, but don't think about it too long. And some final thoughts here on business interruption insurance. In terms of the analysis, the first thing you want to do is look at the policy language, because what you're really looking at is a contract dispute, your insurance contract. It may cover or exclude an interruption resulting from a government order or action. It may cover or exclude an incident resulting from a virus or a contagious disease. It might or may not say you need the actual physical loss to trigger the right to collect business interruption insurance. And finally, the real wild card here is you don't know what a court's going to do. You know, there's very creative ways to read contracts when you want to reach a result. Some people will say, the judge will say, this is how I want to roll, and they'll back into it. And they may say, as a matter of public policy, we're going to protect these people because they paid their premiums for their insurance. They reasonably anticipated when the business was interrupted, they collect. Here comes COVID, here comes a government order, and it would be unconscionable as a matter of law to deny them coverage. So we just need to see where that one plays out. And again, this is a very new evolving area. So if you have issues, again, reach out, call me, email me, and we'll shoot for that sweet answer. And the following area that I'd like to chat about is this a constitutional taking? So the way law works in our country, the government can't just take your property. They have to pay you what's called just compensation under that. And Eva's going to talk about a case like this later on. So if they want to build an airport If the government wants to expand a park, if you're going to build an expressway, police station, whatever it is, and it's for a necessary public purpose, the government can take your property, but they have to pay you. And there's also an inverse condemnation, which means they didn't directly take it, but they really did take it, and then you have the right to compensation. So the question here is, again, your business is closed due to COVID. Do you have the right to recover any just compensation? So what courts have generally held is the government doesn't have to pay if the damage to the property is done to address a public emergency. Let me give you an example. There was a fire raging, and the firefighters wanted to build a fire line. So what that meant is burning down property that was in good condition, so when the fire got there, it wouldn't spread. So they went to someone and said, "We'd like to burn down your property." The person said, "Well, I personally don't think that's a good idea. Why don't you burn down my neighbor's property?" It's like, no, your property, we're going to burn it down to create this fire line. And by the way, do you have some gasoline and matches? Maybe you can help us burn down your property. So obviously the person wasn't too excited about this. They sued, and the court said, "Sorry, no compensation. It was to address a public emergency." There's another case where there were these cedar trees that had this cedar rust disease, and they wanted to cut down the trees so it didn't spread to a nearby apple orchard. So they went to the owner of the property. They said, "We'd like to cut down your trees." He said, "No, I don't think it's a great idea. I mean, these trees, they're my livelihood." They said, "Sorry, we're going to cut them down. Do you have a chainsaw we could borrow? That might make our work go faster." Again, person sues, and court says, "Nope, no compensation because this was to address a public emergency." So a lot of these, it's going to depend on the facts. So for example, if the shutdown is applicable to all companies, it's less likely to constitute a constitutional taking because the burden is shared equally. But if the government draws an arbitrary or unreasonable line between what's essential and what's not essential, it could be more likely to be deemed a taking. I mean, there's been owners of bowling alleys saying, "Well, explain to me, please, why if you go to a bowling alley and the lanes are 6 feet apart and people are wearing masks, why that's unsafe and we can't operate. But if you go to a crowded casino and you're pulling the lever on the one-armed bandit, that's safe." I mean, is that really a rational distinction? So the courts might have to sort that out. And again, what the government is going to do is say there's the public defense necessity. There's an emergency, we have to do it, so it's no compensation is due. And again, that's going to be a matter of how the courts deal with it. So unless there's any questions, that's all I have. And my warm-up act is now over for EVA, which is the main event here today. And again, feel free to reach out to me at any time. I'm always happy to help. And stay safe, everybody, because that COVID could be nasty. Thank you very much. And I'll turn it over to Nancy to introduce EVA now.
Yes, thank you, Greg. That was great. Boy, I tell you one thing, COVID sure has given us a lot of new things to talk about, hasn't it?
Absolutely.
Yeah, and I don't think it's going to stop anytime soon. We're just going to take a couple seconds here while Eva gets her PowerPoint up. And boy, I mean, that really was just a couple of seconds. So Eva, you got a lot of stuff to talk about from the legal side too. So go ahead whenever you're ready.
Well, first of all, I want to thank Gregg for his very interesting and informative presentation. I really enjoyed it. So it's an evolving area of the law, and anybody who has those type of issues should definitely contact you. I'm an attorney as well. I typically instruct on commercial and industrial property tax appeals. This year I'm doing something different. I'm going to talk to you about 5 notable real estate cases in 2019 and 2020. 3 of these are federal cases and 2 are state cases. So I'm going to start with the federal. The first case here is Sitzer versus National Association of Realtors. This is an ongoing case. The plaintiffs are persons who listed their homes for sale on a Kansas City area multiple listing service. In April of 2019, the plaintiffs filed a class action complaint against the National Association of Realtors and 4 of our nation's largest real estate broker franchisors. Each of the franchisors has a significant presence in the Kansas City area. Now, in their complaint, the plaintiffs alleged that NAR and the franchisor defendants had violated antitrust laws, federal antitrust laws, by conspiring. Oops, I see I lost my slideshow view here. Let me see if I can get back to it. Okay, there we go. By conspiring to require home sellers in the Kansas City area to pay a commission to the broker representing the buyer, and by inflating the amount of the buyer-broker commission by setting it at half of the total commission paid by the seller. Now, the cornerstone of the plaintiff's antitrust claims is that NAR adopted and implemented a rule which requires the brokers to make an offer of buyer-broker compensation when listing a property on the multiple listing service. And plaintiffs refer to this rule as the adversary commission rule. They allege that it is anti-competitive because it forces home sellers to pay a cost that would otherwise be paid by the buyer. The plaintiffs contend that the franchisor defendants orchestrated the adversary commission rule by actively participating in the management and operation of NAR, including the development of its rules, and by requiring all of their franchisees to comply with NAR's rules. The plaintiffs insist that if the adversary commission rule did not exist, the cost of buyer-broker commissions would be paid by the buyer-broker's clients, the buyers. Thus, according to the plaintiffs, the adversary commission rule restrains price competition among buyer-brokers because the person who actually retains the buyer-broker, the buyer, does not negotiate or pay the commission for his or her broker. And the plaintiffs contend that if it were not for the adversary commission rule, listing brokers would set a commission to pay only themselves and would engage in more vigorous competition with one another to lower their commissions or provide additional services to justify the commission rates. Well, the defendants didn't think these arguments were very compelling. So they filed a motion to dismiss the plaintiff's complaint. And the defendants argued that the plaintiffs had mischaracterized NAR's adversary commission rule. They reasoned that it merely provides that when placing a listing on the MLS, the listing broker must make an offer of compensation to the buyer brokers, which could be as little as 1 cent. And the fact that the compensation was typically much more than 1 cent simply reflected a common sense effort by sellers to attract buyers to their homes. And far from being anti-competitive, this was the free market at work. Therefore, the defendants say the adversary commission rule cannot serve as a basis for finding anti-competitive conduct, and the court should dismiss plaintiff's complaint. I would love to hear from all of you as to whose arguments you think are most compelling. But at any rate, the court disagreed that the plaintiffs had not stated a valid claim, and it denied the defendant's motion to dismiss. The court explained that plaintiffs had pled sufficient facts which, if proven true, stated an antitrust claim. However, the merits of plaintiffs' antitrust claims could not be determined until after discovery, which would produce a more fully developed evidentiary record. Now, I've looked at the court's docket, and it's quite extensive. The parties have been engaging in extraordinary, extensive discovery. But as in this presentation, there has not yet been a ruling on the merits of plaintiffs' antitrust claims. Nevertheless, this case is still instructive at this stage of the litigation because it serves as a reminder to real estate agents and their brokers that anti-competitive conduct with respect to real estate commissions could lead to expensive litigation. And I'm not saying that the defendants did engage in anti-competitive conduct. This will be decided later in the litigation. Now the next case, let me advance the slide here. There we go. The next case also involves anti-competitive conduct, and it also is an ongoing case. This is the Top Agent Network versus the National Association of Realtors. And Top Agent Network, who I'll refer to as TAN, is a real estate network whose membership is limited to the top 10% of agents around the country. In May of this year, 2020, TAN filed an antitrust lawsuit against the National Association of Realtors and 2 California Realtor associations. The lawsuit stems from NAR's Clear Cooperation Rule, which prohibits NAR members from privately marketing properties without using the multiple listing service of a NAR-affiliated association of realtors. TAN alleges that the Clear Cooperation Rule is part and parcel of a conspiracy by NAR and its affiliates to shut down competition. According to TAN, a small number of agents are responsible for the vast majority of all home sales. And many of these experienced agents have established their own networks and created methods outside of the MLS to serve their clients. They are therefore less reliant on the MLS as a percentage of their overall business than less experienced or lower producing agents. TAN alleges that alternative networks, such as TAN, pose a problem for NAR. If a home for sale is never listed on the MLS and is instead marketed through alternative means, most NAR members would have a reduced chance of being involved in the transaction and would therefore be less likely to earn a commission. Absent the ability to earn a commission from using the MLS, NAR's members would have less incentive to pay NAR to access the MLS. Off-MLS sales then threaten NAR's revenue, its market dominance, and its entire reason for existing, says TAN. Because the number of off-MLS sales has grown significantly in recent years, TAN alleges that NAR and its affiliates have a huge incentive to stamp out these alternative networks, including TAN, to ensure home sales must be listed on the MLS. So in short, TAN contends that NAR promulgated the Clear Cooperation Rule to maintain its market dominance and eliminate TAN and other alternative listing networks as competitors. This, TAN says, violates state and federal antitrust laws. I'm going to take a quick sip of my water here. Well, the defendants aren't going to take this lying down, of course. And in response to these allegations, guess what? Like in the prior suit, they filed a motion to dismiss TAN's complaint. And they argued in their motion that TAN had stated no legally cognizable antitrust claim because the Clear Cooperation Rule ensures broad access to homes for sale in a particular city or town, and therefore it benefits competition, buyers, and sellers. In defendants' view, TAN is simply seeking to restrict access to the most valuable listings, choosing who can see them and who cannot, in exchange for substantial income from dues paid by its members. Defendants further contended in their motion to dismiss that the antitrust laws exist to protect consumers, not TAN's profitability. Therefore, TAN had not alleged an antitrust injury and as such did not have standing to pursue its antitrust claims. And finally, the defendants argued that the Clear Cooperation Rule merely provides that agents who want to participate in a multiple listing service must publish their listings there. And so therefore, defendants say the clear cooperation rule is not anti-competitive and the court should dismiss Tan's complaint. Again, I wish I could hear from all of you as to whose arguments you think are most compelling, but we're not at that stage of the litigation yet because the court has not yet ruled on defendant's motion to dismiss. Nevertheless, the case is still important at this juncture of the litigation because it is another reminder to real estate agents and their brokers that anti-competitive conduct in connection with the sale of real estate could lead to expensive litigation. And once again, I'm also not saying that the defendants did engage in anti-competitive conduct. That is something that will be determined later in the litigation. Now, the next case is also a federal case. However, it does not involve antitrust claims. As Gregg mentioned earlier, the Takings Clause of the Fifth Amendment to our U.S. Constitution states that private property shall not be taken for public use without just compensation. Most state constitutions contain a similar provision. The Nick case, which I'm going to talk about now, concerns both state and federal takings provisions. The plaintiff in the case, Rosemary Nick, owned and lived on 90 acres in Scott Township, Pennsylvania. And her property included a small graveyard where ancestors of her neighbors were allegedly buried. Apparently, this is fairly common in Pennsylvania. Well, in 2012, Scott Township passed an ordinance which required that all cemeteries be kept open and accessible to the general public during daylight hours. A Scott Township enforcement officer subsequently found the grave markers on Rosemary's property and notified her that she was violating the ordinance by failing to open the cemetery to the public during the day. Well, Rosemary didn't want to do this, so she filed a takings claim in state court, arguing that the Scott Township ordinance had affected an unlawful taking of her property. Now, Rosemary was required to file her takings claim in state court rather than federal court because 35 years ago, the Supreme Court held that a property owner whose private property was taken by a local government without paying for it could not bring a takings claim in federal court until a state court had first denied the property owner's claim for just compensation under state law. And this was what the Supreme Court's Williamson decision. And the relevance of this Williamson ruling will become apparent in a few moments. Well, back to Rosemary's state takings claim. Scott Township withdrew its ordinance violation notice after the lawsuit started and agreed to withhold enforcement of the ordinance during the state court legal proceedings. However, the state court refused to rule on Rosemary's taking claim, reasoning that without an ongoing enforcement action, Rosemary could not demonstrate any harm for the ordinance. That's something you always have to prove in every lawsuit. The plaintiff must show harm. So Rosemary then filed a lawsuit in a Pennsylvania federal district court, alleging that the ordinance violated the takings clause of the Fifth Amendment to our U.S. Constitution. However, the federal court dismissed Rosemary's federal takings claim, and the Third Circuit Court of Appeals affirmed, reasoning that they were bound by the Supreme Court's earlier ruling in Williamson that takings plaintiffs must seek just compensation in state court before filing a takings claim in federal court. But in the state court proceedings, Rosemary had not requested just compensation. She had only alleged an unlawful taking of her property. Wow, sounds like Rosemary's kind of in a catch-22. She can't get relief in state court. She can't get relief in federal court. Well, her lawyers didn't give up. They filed a petition in the U.S. Supreme Court, that's the federal court, to revisit the issue of whether a property owner must seek just compensation under state law in state court before bringing a federal takings claim in federal court. The Supreme Court not only granted Rosemary's petition, it overruled its earlier decision in Williamson and held that a property owner may bring a takings claim in federal court as soon as the government has taken the owner's property without paying for it. The property owner is not required to seek just compensation in state court first. So why is this important? Why do you care whether you're in state court versus federal court? Well, it's important because for two reasons. Federal judges are generally more familiar with constitutional claims than state court judges. That's my opinion as a lawyer. Moreover, because they are appointed for life, I believe they are not as likely to be influenced by local politics and local views as state court judges who are elected and need to run for re-election in order to maintain their judicial position. So the Supreme Court's decision in Hick is a welcome ruling for property owners with a takings claim. I am done now with my federal cases, and we're going to move on to the last two cases, which are state court cases. This first one is Raffaelli LLC versus Oakland County. This is a recent Supreme Court decision involving two parcels of real estate. The first parcel was a rental property in Southfield purchased by Raffaelli LLC for $60,000 in 2004. The second parcel was a 2.7 acre vacant site in Orchard Lake Village purchased by a Mr. Ohanesian. In 2011, Raffaelli and Mr. Ohanesian failed to pay their 2011 property taxes. So Oakland County sent them notices of delinquency. Raffaelli made partial payments to the county, but never paid the full amount of the delinquency. Mr. Ohanesian completely failed to pay his delinquency. So in 2013, both properties were forfeited to the county. The forfeiture amount in Raffaelli's case was $8.41 in unpaid property taxes, plus interest, penalties, and fees for a total of $286. In Mr. Ohanesian's case, the forfeiture amount totaled approximately $6,000, inclusive of the unpaid property taxes, interest, penalties, and fees. In 2014, Oakland County sold Raffaelli's property at auction to a third party for $24,500 and kept all of the surplus proceeds that exceeded the $286 tax debt Raffaelli owed the property, a surplus of over $24,200. Oakland County also sold Mr. Ohanesian's property at auction to a third party for $82,000 and kept all of the surplus proceeds that exceeded Mr. Ohanesian's $6,000 tax debt, a surplus of $76,000. Sounds fair, huh? Just kidding. Well, Mr. Ohanesian and Raffaelli subsequently filed a joint lawsuit against Oakland County in the Oakland County Circuit Court. And they alleged that by keeping the surplus proceeds from the tax foreclosure sale of their properties, the county had taken their properties without just compensation in violation of the takings clauses of the United States and Michigan constitutions. However, the Circuit Court disagreed and dismissed the lawsuit, and the Michigan Court of Appeals affirmed. our Michigan Supreme Court reversed. It explained that the United States and Michigan constitutions both prohibit the taking of private property for public use without just compensation, and that decades of cases decided before Michigan's constitution was ratified in 1963 all recognized that a former property owner's property right to collect the surplus proceeds realized from a tax foreclosure sale of the former owner's property. So therefore, the ratifiers of our Michigan Constitution must have understood this right to be protected under the Takings Clause of Michigan's Constitution. So our Michigan Supreme Court held that Oakland County's retention of the surplus proceeds was an unconstitutional taking of private property for public use without just compensation. The court also held that just compensation equals the amount of the surplus proceeds generated from the tax foreclosure sale, and that Raffaele and Mr. Ohanishan were entitled to the surplus. I'm going to take another quick sip of my water here. The final case that I'm going to discuss is Locker versus Estate of Bradley M. Zimmerman. Michigan's Seller Disclosure Act requires the seller of any interest in real estate consisting of 1 to 4 units to complete a statutorily prescribed seller disclosure statement, noting on that statement the condition of numerous components of the real estate. And the seller disclosure statement must be delivered to the purchaser before the purchaser signs a binding purchase agreement. Otherwise, the purchaser may back out of the deal before the closing. In 2015, Paul and Patricia Locker purchased a home in Pleasant Ridge, Michigan. At the time of their purchase offer, the home was owned by Bradley and Josephine Zimmerman, both of whom were suffering from dementia and living in an assisted living facility. However, their daughter, Lynn Zimmerman, had a power of attorney to sell the home. She filled out the seller disclosure statement, even though she lived out of state and knew practically nothing about the home. Uh-oh. Well, sometime after the closing, the Lockers sued Lynn and her parents for violating the Seller Disclosure Act and for committing common law fraud. The Lockers alleged that Lynn had failed to disclose numerous defects in the home, including a severe mouse infestation, posts in the crawl space holding up parts of the main floor, rotten plywood flooring in the master bedroom as a result of roof leaks, rotten plywood flooring in the laundry room due to water intrusion, a leaking sliding glass door, carpenter ants in the house, improper installation of the water heater, chimney deterioration, water leaks in the basement, and multiple roof leaks. Whew. However, based on the evidence the parties actually submitted to the trial court found that Lynn and her parents did not violate the Seller Disclosure Act or commit common law fraud. So the Lockers appealed. And in considering the Lockers' claims, the Michigan Court of Appeals explained that the Seller Disclosure Act allows a purchaser of residential real estate to terminate the purchase agreement before title is transferred if disclosures were not made as required in the Seller Disclosure Statement. The Seller Disclosure Act provides no other remedy. Therefore, the Lockers had no legally cognizable claim under the Seller Disclosure Act because they had already received title to the property. The Court of Appeals did, however, look to the disclosures or lack thereof in the Seller Disclosure Statement to determine whether the lockers had stated a legally cognizable claim for common law fraud, as opposed to a claim under the Seller Disclosure Act. The Court of Appeals explained that to prove a claim of common law fraud, a plaintiff must, among other things, establish that the defendant made a material representation and that the representation was false. Greg, I bet you knew that, right? Remember that from law school? Anyway, the Court of Appeals found that the lockers had not shown any false representation made by Lynn or her parents. The Court of Appeals explained that on the seller disclosure statement, Lynn had indicated that the condition of numerous aspects of the home were, quote unquote, unknown to her, and that she had left several questions blank. The Court of Appeals held that this silence could not be interpreted as a material representation. The Court of Appeals also found several factual problems with the lockers fraud claim. The principal one being that the lockers home inspector had discovered most of the flaws that the lockers complained about before they finalized their purchase agreement. Accordingly, the Court of Appeals affirmed the trial court's ruling that the Zimmermans had not committed any fraud in connection with the sale of their home. Now, there are two important points I want you to take away from this case. Number one, the only remedy for violation of Michigan's Seller Disclosure Act is that the purchaser may terminate the purchase agreement before the title is transferred if the seller fails to make the disclosures required in the seller disclosure statement. But number two, if the purchaser believes that he or she was fraudulently induced to purchase the home, the disclosures or lack thereof in the seller disclosure statement may be considered in determining whether the seller committed common law fraud. Well, I see that my time is up, and I hope you have found my cases interesting. If you have any questions about them or about property tax appeals, the topic I typically instruct on for CBOR, you may contact me using my contact information in this last slide. So I want to thank you very much for your time and attention, and have a wonderful day. Thank you.
Thank you both, Eva and Greg. You guys did a great job. We really appreciate it. And for you attendees, I strongly recommend and encourage that if you have any follow-up questions, you contact Greg and Eva directly. Thanks again, everyone, and hope you enjoyed this class.